Hello and welcome to the MPG Zoom room. We are very pleased to have so many of you attending this presentation today, and thank you all for joining us. My name is Michael Gallucci and I manage the chartered surveying firm MPG, which has offices in London and Dubai. I'm a chartered QS and quantum expert witness with a law degree in international arbitration and contract law. I've been working in the UK and Middle East since 1988. Our team at MPG includes quantum and delay experts, claims and cost consultants, and legal specialists in dispute resolution and insolvency. I'm assisted today by Michael Blackburn. He's a construction and engineering legal expert in domestic and international disputes. He was head of construction and engineering disputes group at DAC Beechcroft for the last 12 years and has been practicing law since 1981. He advised on procurement and contract formation and has knowledge of all of the major contract forms. He's also familiar with all forms of dispute resolution, including mediation, adjudication, litigation through the courts, and international arbitration. He works for clients all over the world, including Europe, North and South America, the Middle East, Africa, and is listed on the Legal 500 as an expert in construction. Before we start, Michael, would you like to say a few words?
Well, I think you've summed up very fairly, Michael. Obviously, I've been in this game for many, many years and have had plenty of experience in the past, particularly in relation to defending and processing global claims and also dealing with Fidic disputes. I also should just add that I also sit as an adjudicator accredited by TEXA, but look forward to this session and hope that if you have questions, do feel free to interrupt us as we go along in case there are any issues you have difficulty understanding or purely simply probably because of our presentation or whatever. Then I look forward to discussing these matters further with you. Thank you, Michael.
No problem, no problem. As Michael said, if you have any questions you'd like to ask as we proceed through the presentation, click on the chat button or raise your hand, post the question in the chat room, and we'll attempt to answer all your questions if the time allows. If I'm unable to answer your question, we can take your details and get back to you after today's session. Today, when we make reference to Fidic contracts, we're generally going to be looking at the yellow and red books from 1999. We are going to have a separate presentation on the 2017 versions at a later date, and we can also then discuss the differences between 1999 and 2017 and how they may affect your project. If there's any other subject matter that you wish us to bring up today, that you'd like us to look at later on and explore further, just put a note in the chat box and we'll review your suggestions at the end of our session, and then we can arrange to do a further session to cover what you'd like us to look at. So today we'll be looking at causation, the definition of civil law considerations of global claims, how global claims are handled in the Fidic contract red and yellow books 99, and we'll finish off with a brief summary and questions and answers. So let's start with causation. Causation is one of the topics that are rarely discussed, but play a key role when dealing with commercial disputes. In construction disputes, all parties, including claimants, defendants, independent experts, arbitrators, judges, have to deal with causation during the course of their role. Causation is determined by a strong logic, i.e., a factual matter and the rules of interpretation being a legal matter. Causation in construction contracts is relatively simple to understand. In construction, if one of the contracting parties does not fulfill its obligation, it may cause the other party to incur damages. There are three major principles which may limit the damages, being causation, remoteness, and/or mitigation. Therefore, causation is developing a link between the event and the damage. As you can see on the slide, you need to consider two aspects: one, the factual component, and two, the legal condition. As in the law, prepared to attribute the damage to the event, notwithstanding that they may be factually connected. The difficulties facing parties identifying the factual components can be greatly assisted with the production of contemporaneous records of the events as they occur on site. Lord Drummond-Young said in John Doyle and Lang Management Scotland that for a loss and expense claim to succeed, a claimant must prove three matters. First, the existence of one or more events for which the defendant is responsible. Second, the existence of loss and expense suffered by the claimant. And third, the causal link between the event or events and the loss and expense. When examining the causation, the claimant must focus on whether the damage would not occurred but for the event that happened, and also what probably would have happened on the balance of probabilities. Would the damage have happened anyway? Is there a close connection between the event and the damage? Was it a breach of duty that caused the damage, or merely an occasion that caused the damage? Was there an intervening event or break in the chain of causation, or was there concurrency in respect to the causation? The burden of proving that the event caused the damage is and always will remain on the claiming party, and it's for them to prove on the balance of probabilities. Keating on construction contracts says that a global claim is one that provides an inadequate explanation of the causal nexus between the breaches of contract or relevant event matters relied upon and the alleged loss and damage or delay that the relief is claimed for. The operative words in this statement is inadequate explanation. Before we start to talk about global claims, I'll hand over to Michael, who gives us a brief insight into why global claims may not be such a good idea. Michael.
Thanks, Michael. Basically, there are three main objections to global claims. The first is that it offends the generally accepted legal position, as Michael says, that a contractor must prove the causal link between the sums claimed and each individual event. So in effect, if you plead a global claim, it reverses the burden of proof. The employer ends up having to undertake a detailed analysis of the events and the quantum to show why the global claim is not justified. So the courts don't like that very much, the idea that you present a global claim saying all the events have caused all the delay, and then leave it to the employer or main contractor with a subby claim having to prove why the global claim is not justified and why that doesn't work. The second objection is that it ignores other explanations of the causes of additional costs for which the contractor is responsible. For example, a lack of supervision or cost control, or a too low a tender price, and whether or not there's been labour or material shortages on the job. Thirdly, it avoids the need to plead a precise case. And in Hudson's on global claims, said global claims are almost invariably unfair and highly prejudicial to the employer, since they avoid indicating the precise case to be met and enable the contractor to change course during the evidence. And employers often say that they cannot understand the case against them and that the claim should be struck out. So for the first sort of 10 years or more of my practicing life, when acting for employers, one will be right and being presented with a global claim, one would be writing to them, asking them to set out the basis upon which their claim works. How can they say that all of these events have caused all of this delay? And it's fair to say that until 10, 15 years ago, global claims were very much frowned upon. There was even an argument to say that global claims couldn't necessarily work. But cases such as John Doyle and Lang have removed, for example, what I call the exocet defence. The exocet defence was that if you could show that just one of the causes of delay was not the employer's responsibility, then the claim would fail. But in John Doyle and subsequent cases like Walter Lilly, as we'll come on to, that exocet defence was removed because the courts have now said you can safely ignore the fact that some of the claims don't necessarily work and still be able to proceed with your claim, obviously, as long as you can prove it on a balance of probabilities as set out earlier. Thank you, Michael.
Thank you. So effectively, when looking at global claims, generally the position is that the contractor notifies the engineer of a number of delay events, then advises the engineer of the cumulative effect of all of the delay, then also advises the engineer of the total amount of loss incurred. These notices could be the late provision of design drawings, specifications, changes, variations, denials of access, employer prevention, etc., to parts of the site, interference by other contractors, and many other events. However, in a global claim, the contractor is unable to identify the causal links between each of the individual delay events and each of the individual losses incurred. So an example of a global claim is that the employer finds it easy, as Michael says, to reject such a claim. He could simply assert that the contractor had insufficient labour on site, or there are inadequacies in his tender, and straight away parts of the global claim may start to fail. Walter Lilly and Mackay was described by Mr. Justice Aikenhead as being a full-blooded conflict between the parties in which there seems to have been little, no, or belated room for compromise. The judgment provided valuable guidance on the preparation and likely resolution of claims, including in relation to the correct approach to determining extension of time claims in England and Wales, where there is concurrency. Global claims and the nature of information that contractors are required to provide was also covered, and how it should be submitted in a normal claim format. Walter Lilly was engaged as a main contractor under a JCT standard form of contract to build 3 houses at 1, 2 and 3 Bolton's Place in Earl's Court in London. Mr. and Mrs. Mackay were to occupy number 3 house. Mr. Mackay, in association with Mr. Daniel and Mr. West, formed a company DMW as the vehicle to which the development would be carried out, and there was little, if any, design had been completed prior to the involvement of Walter Lilly. As a result of this, the project suffered from considerable delay. Mr. Aikenhead's judgment said that whilst there was nothing in principle wrong with a global claim, it may raise evidential difficulties. The contractor needs to show that the loss incurred would not have been incurred in any event, that the contractor's tender was sufficiently well priced, and no other matters are likely to have caused the loss. He went further and said, even in an event which is not the fault of the employer caused or contributes to the global loss, that does not mean that the contractor will recover nothing. You have to consider the impact of the event, the possibility for amount to be deducted for the individual event which is not the employer's responsibility, and that the claim is subject to any contractual restrictions on recovery of loss and expense. Michael, would you like to talk to us about your view on the Walter Lilly and Mackay case?
Yes, I think this is another example of the courts now allowing global claims to be made as long as they satisfy an appropriate test. And obviously in this case, there were a substantial number of defects on this job, and the question was who was liable for those defects. Was it the fault of the design team, or was it the fault of the contractor? And effectively, what Walter Lilly was saying was that they were entitled to an extension of time for the whole of the additional time they were held on site due to these various defects, but were not actually linking them individually to the delay. So it was a classic sort of global claim case. And as Michael set out, as Justice Aiken confirmed, that as with any claim for loss and expense, contractor must prove a global claim as a matter of fact. Just to remind you again, what he said was that the contractor must prove on a balance of probabilities that first, events occurred which entitled it to loss and expense. Secondly, that those events caused delay and or disruption. And thirdly, that such delay or disruption caused it to incur loss and or expense. So the contractor still does need to prove, firstly, that each of the events occurred, that the employer, secondly, that the employer bared the risk of those events, that those events, thirdly, that those events resulted in delay or disruption, and fourthly, that the delay and disruption caused it to incur loss and expense. I think the most important point is that proving loss and expense, the actual loss and expense, is the most difficult because of the lack of direct causal links. However, the contractor should endeavour to prove its case by providing adequate pleadings supported by appropriate evidence. Thank you, Michael.
Thank you. So another example of where a global claim was discussed in the courts was AMEC and Stork. In this case, there was a claim for £7 million, which was mostly a claim for disruption on a project in the North Sea. There were allegations that there was disruption and additional labour costs were caused due to variations, late, irregular delivery of drawings, materials, and equipment. And in the case, the court provided its view on how it considered disruption claim should be presented by stating, whatever method of proof is adopted, the pleading should set out a party's case as to causative events, causation, loss, and methods of proof with sufficient clarity so as to enable the opposing party to know what case it is facing. The court did not indicate a favoured method or approach to calculate the extent of disruption and noted that Stork had not suggested an alternative method to the one used by AMEC. This suggests that any method of measuring disruption could be acceptable if it is comprehensible, logically broken down, and if there is no other alternative method has been suggested. Interestingly, the case also gave a decision in respect of costs. AMEC used its own staff to carry out much of the work involved in the collection and analysis of the evidence, including the preparation of visual aids on behalf of the expert to be used in the courtroom. Thornton QC held that if a necessary expense was undertaken by AMEC, which would have been incurred at a lower cost than if AMEC's solicitors and experts had carried out the work, then the time charges involved in employing AMEC's own staff to do the work should be recoverable. Now we can move on to Qatar, UAE, and Saudi. The civil codes of Qatar, UAE, and Saudi have requirements which are generally taken into consideration by judges in local disputes when assessing the parties' intentions, including good faith, any implied requirements imposed by the law, the trade customs, and the justice considering the nature of the transaction. The concept of mustalzimat has roots in Sharia law, and it is possible for global claims to be based on mustalzimat and good faith obligations rather than just under the contract. Good faith is a fundamental doctrine of Saudi, Qatari, and UAE law, originating from the Sharia law maxim that there shall be neither harming nor reciprocation of harm. Under Sharia, a covenant of good faith is implied in all contracts. This concept of good faith is enshrined within UAE law and can be found at Article 246 of the UAE Civil Code. Amongst other things, parties must not seek to treat each other unfairly, and any unreasonable reliance on the strict wording of the contract is also not allowed. Decisions of the Dubai Court of Cassation have ruled that an act of bad faith by one contracting party may provide a cause of action for the other, and the duty of good faith is therefore overarching. This is unlike English law. In deciding whether an act constitutes bad faith, the court may also look at Article 106 of the UAE Civil Code, which provides that a party is prohibited from exercising its rights if it is intended to infringe the rights of another party, or if the outcome is contrary to the rules of Islamic Sharia, the law, public order, or morals. There's a desired gain is disproportionate to the harm that will be suffered by the other party, or it exceeds the bounds of custom or practice. There are some potentially wide-ranging ramifications of this, including that good faith is most likely to be applied to evidence for or to support an allegation of breach. Where, for an example, building materials are found to be defective, a breach will be easier to establish if there's been some attempt to conceal this or cover up that the materials are once incorporated into the works. Reliance on time bar notices, for example, Fidic's clause 20.1, are likely to be restricted where a party is seeking to rely on it when they knew about the breach previously. For example, if notification of the claim was made informally and is recorded in a meeting minutes or similar, but was never formally made, then it may be able to rely on that in the courts under that good faith principle. In other words, if you deny a claim due to time bar when it's already been communicated, that would be an act of bad faith. Avoiding liability for a very substantial claim due to a time bar may also be unlawful where the losses were serious and unequal with the employer's contractual claim to be notified in the required time period. For example, 28 days under clause 20.1. Article 106(1) of the UAE Civil Code provides that a person shall be held liable for an unlawful exercise of his rights. And this, together with the good faith obligation, may be used to challenge the effectiveness of a time bar in such circumstances. Whilst the UAE Civil Code does not provide that parties may fix a pre-agreed compensation mechanism or amount in their contract, the court may also vary the pre-agreed amount of compensation or damages to equal the actual loss in any event, regardless of whether there was an act of prevention on the part of the employer. It could be argued that the causal nexus is less important in civil law jurisdictions. As we've now discussed the concept of good faith and bad faith, now let's look at the Fidic contract and the clauses under which you need to serve your notices. Clause 20.1 is the notification of delay clause. The contractor must give notice to the engineer of a time or money claims as soon as is practicable and not later than 28 days after the date on which the contractor became aware or should have become aware of the relevant event or circumstance. As you can see, time is of the essence, and you need to notify not later than 28 days after you became aware or should have become aware if you are the contractor. Clause 20.1 goes further and it states the contractor must submit a fully particularised claim after 42 days. The engineer is to respond to this claim within 42 days of receipt of the claim or such other period as may be agreed. If the event giving rise to the claim has a continuing effect, the contractor must submit further interim updated claims at monthly intervals until a final claim is to be submitted, unless agreed otherwise, within 28 days of the end of the claim event. Clause 3.5 deals with the engineer's determination, and it states that the engineer should consult with each party in an endeavour to reach an agreement. If an agreement is not achieved, the engineer should make a fair determination in accordance with the contract, taking due regard of all of the relevant circumstances. The engineer is to give notice of the determination with full support in particulars to both parties. Michael, do you want to talk to us about clause 20.1 and its condition precedents?
I mean, under English law, I suppose the leading case in relation to clause 20.1 is Obrascon Guarte Lane SA against Her Majesty's Attorney General for Gibraltar, which is a decision of Mr. Justice Aikenhead. It related to the building of a tunnel beneath the airport runway in Gibraltar. Basically, in the old days before this tunnel was built, you had to close the road that crossed over the main road into Gibraltar that crossed the airport runway before you could land or planes could take off. So it was quite an important tunnel. Unfortunately, the job went very badly for the Spanish contractor, which is all a bit ironic, really, due to the allegedly unforeseen or excessive ground conditions. These excessive ground conditions were all to do with military ordnance that had been expended by the Brits and the Spanish when having disputes over Gibraltar itself. And Aikenhead was assessing a Fidic contract here, in particular clause 20.1, and confirmed that the 28-day notice was a condition precedent, i.e. that you had, under English law, to serve the notice within 28 days of becoming aware of a matter entitling you to an extension of time. However, when determining when that 28-day period ran from, he took into account clause 8.4, which provided that the contractor should be entitled, subject to clause 20.1, to an extension of time for completion, if and to the extent that completion is or will be delayed by any of the following causes. And obviously that was the ground conditions, etc., etc. And what Mr. Justice Aikenhead decided, that in relation to an extension of time claim, that the 28-day period could run from when it became clear to the contractor that there would be a delay, i.e. what we'd call a prospective delay, or when the delay has started to be incurred, i.e. a retrospective delay. So a certain relaxation in terms of when the 28-day period ran from, even though you're finding its condition precedent. And obviously, as Michael has already mentioned, in relation to other jurisdictions, and certainly in relation to civil law, they're never terribly enthusiastic about these condition precedent clauses. And in relation to employer claims, it was also found that there were a condition precedent under clause 2.5, as Michael come on to talk about. And in the case of International Caribbean Limited and against National Insurance Development Company, Trinidad and Tobago, there the employer was relying upon the particulars from delay reports, which were not found to be an appropriate method of notice. Thank you, Michael.
Thank you. So now we'll talk about the elements within the Fidic contracts. So the claim provisions in Fidic Red and Yellow Book 99, the mechanism is, as we've discussed already, Michael's brought up clause 8.4. We've looked at clause 3.5 and clause 20.1. And these act as claim gateways for you to make your claims in respect of the construction project. Clause 8.4 is the extension of time clause. The contractor should be entitled, subject to 20.1, to an extension of time for the completion if and to the extent that completion for the purposes of subclause 10.1 taken over the works is or will be delayed by any of the following causes. So the following causes that you can have an extension time for are variations or substantial changes, causes of delay giving entitlement extension time under the subclause of the conditions include exceptionally adverse climatic conditions, unforeseeable shortages in the available personnel or goods caused by epidemics or governmental actions, which has obviously been quite relevant of late. Any delay, impediment or prevention caused by or attributable to the employer, the employer's personnel, or the employer's other contractors on the site. If the contractor considers himself to be entitled to an extension of time for completion, the contractor should give notice to the engineer in accordance with clause 20.1. And when determining each extension of time under clause 20.1, the engineer shall review previous determinations and may increase but not decrease the total extension of time. The key phrases in clause 8.4 are subject to clause 20.1, so it makes the issue of proper notices a precondition of this entitlement, and completion for the purposes of subclause 10.1, i.e. the delay must be on the critical path. Now we look at the clause 3.5, determinations by the engineer. Whenever these conditions provide, the engineer shall proceed in accordance with subclause 3.5 to agree or determine any matter, the engineer shall consult with each party in an endeavour to reach agreement. If agreement is not achieved, the engineer shall make a fair determination. So the key here is fair determination in accordance with the contract, taking due regard of all of the relevant circumstances. You should note that the Fidic 87, which may still be around, the need for the engineer to be fair was previously referred to as being impartial. So there has been a change there in 99, and it's been further changed in 2017, which we'll deal with in a later seminar. 20.1. Within 42 days after the contractor becomes aware or should have become aware of the event or circumstance giving rise to the claim, or within such other period as may be proposed by the contractor and approved by the engineer, the contractor shall send to the engineer a fully detailed claim, which includes full supporting particulars of the basis of the claim and of the extension of time and or the additional payment claimed. Excuse me. If the event or circumstance giving right to the claim has a continuing effect, this fully detailed claim shall be considered as interim, and the contractor shall send further interim claims at monthly intervals, given the accumulated delay and or amount claimed and such further particulars as the engineer may reasonably require. So there's an awful lot of work to be done once you notify your claim within 42 days. You need to prepare these documents, and this is the work that keeps the claims consultants happy when they have to submit these claims on your behalf, if you can't have the time to do them yourselves, and then continue to update them on a monthly basis. The contractor shall send a final claim within 28 days after the end of the effects resulting from the event or circumstance, or within such other period as may be proposed by the contractor and approved by the engineer. Within 42 days after receiving a claim or any further particulars supporting a previous claim, or within such other period as may be proposed by the engineer and approved by the contractor, the engineer shall respond with approval, with disapproval, and detailed comments. He may also request any further necessary particulars, but shall nevertheless give his response on the principles of the claim within such time. So it's the duty of the engineer to give you a response. There are a number of clauses in Fidic under which you can bring claims. Clause 1.5 is for the errors and ambiguities in the documents. Clause 1.9 is for errors in the employer's requirements. Clause 2.1 is for your late access to site or areas of the site. Clause 3.3 is instructions of the engineer. Clause 4.6 is cooperation with others, and clause 4.7 is errors in the employer's reference materials for setting out. Clause 4.12 is for ground conditions, and 4.24 is for fossils and antiquities. Clause 7.4 is for testing, and clause 8.9 is for suspension for the employer's convenience. Clause 10.2 is for partial taking over, and 10.3 is for interference with tests on completion. Clause 12.2 covers delays to tests on completion, and 12.4 is for delayed access following a failed test. Clause 13.7 is for changes in the laws, and 16.1 is for suspension for non-payment. Clause 17.4 is for claims from employers' risk items, and clause 19.4 is force majeure. However, some of these may not be in these are all in the standard contract, but some are maybe amended out of your contract, so you need to check your particular contract to see if these clauses are there and if they've been amended or not. So you need to submit your detailed particulars within 42 days. The delay must be on the critical path. The delay must fall within 8.4 A to E. The engineer approves or disapproves with comments. Fidic 99 introduces the concept of fairness, and you need to watch out for particular conditions. Establishing program and cost controls. Why is a program necessary for your claim? Programs become yardsticks against which to measure the effects of delay. Fidic requires a baseline program to be produced by the contractor, and the baseline program should be based upon the works included in your contract at the time that the contract was entered into. It should show the intended time and sequence and how the work is intended to progress, and should show a clear and critical path to completion. It should show dates when the employer's input is required with links to the critical path. The requirements to produce a revised program. So revised programs are required when the baseline program no longer complies with the contract and the work on site. The baseline program is no longer consistent with the progress on site, and/or extensions of time have been awarded. You need to produce updated programs, and these are required at regular intervals to record the actual progress, to predict the completion date, and to be used in delay analyses to establish the effects of the delays. Why are cost records and records necessary for your claims? Fidic provides that the contractor may claim for incurred costs in certain circumstances, and the law provides that in the case of a breach of contract, the other party is entitled to be put back in the position that he would have been had the breach not occurred. Costs are all of the expenditure reasonably incurred or to be incurred by the contractor, whether on or off site, including overhead and similar charges. And that's from the red subclause 1.1.4.3. In the case of claim for costs and the claims for delay, it will be necessary to demonstrate the expenditure incurred by the way of the following records: resources present on site, the cost of the resources, depreciation of capital equipment, head office running costs, costs of guarantees, and costs of financing the project. And I'll hand over to Michael, who will talk about the other records that are required to support your claims for delay. Michael.
Thank you, Michael. And just as a general comment in relation to records, just to remind all of you of the comments from Max Abrahamson, who explained that a party to a dispute will learn 3 lessons, often too late: the importance of records, the importance of records, and the importance of records. He went on, it is impossible to exaggerate the extent to which lawyers can find unexpected grounds, often quite real, on which to cast doubt on evidence if it is not backed up by meticulously established records. So just to remind everybody that in terms, particularly in relation to, as we've discussed earlier, for example, a global claim, it's even more important that you actually keep appropriate records. This will include, obviously, timesheets for each employee and or subcontractor, demonstrate where employees were working and when, day worksheets, preferably signed by the contract administrator or project manager, evidence of payments made to employees, such as pay slips, salary records, CIS payment certificates, and or to subcontractors to go with other relevant costs, such as company car allowances, pension contributions, etc., and plant and material invoices. And certainly in relation to global claims, it's important that where you certainly have an extension of time claim, but obviously you're able to back this up with appropriate evidence, including program records, which would include tender programs and programs produced during the currency of the works, progress records, which could include raw data, such as reports and logs, and records compiled to summarize and interpret that raw data. Resource records, which would include obviously labor, material, and equipment, and cost records. These should be project specific, which will cover management, labor, plant, materials, subcontractors, and overheads. Audited accounts may be included, and ideally all invoices should be available electronically. Thank you, Michael.
Okay, so that brings to a close our presentation on global claims, on the appropriate clauses to use in Fidic, and also a discussion in regards to records required to support your claims. We'll be putting together further presentations on the new Fidic forms and also on concurrent delay. And if you have any questions and you want to post them in the chat box or email us at a later date, or also if you want to use the Q&A buttons, then you're more than welcome. But as I say, that's the end of our presentation, and we look forward to seeing you all again. Thank you very much for your time.